A family restraining order is sometimes referred to as a temporary restraining order, or TRO. Family restraining orders are granted to victims of specific crimes or actions committed by family or household members. The accused or respondent must meet the definition of family or household member. This person may be a spouse, former spouse, parent, child, blood relative, a relative through marriage, a roommate, an intimate partner, or people who have children together, regardless of relationship status or living situation. There are no fees to apply for or obtain a TRO. The person applying for the order is called the applicant. The applicant may complete the forms on his or her own or ask for help with the paperwork. The forms include an application and affidavit.
Before completing the application and affidavit, it's important to remember two things. First, that an arrest is not required to apply for protection, and second, that a continuous and present threat of violence must exist. Once the application and affidavit have been submitted to the judge, there are two possible outcomes. The judge may grant an immediate restraining order called ex parte relief, or if the judge needs more information to determine whether to grant the order, there will be a hearing within 14 days.
However, if the applicant indicates that the respondent has firearms, ammunition, or a permit to possess them, the hearing must be held within 7 days. The respondent must surrender any firearms or ammunition to a licensed dealer or law enforcement after the marshal serves them the paperwork. Either way, there's a hearing. The main difference is that ex parte relief does not require an initial hearing to obtain, but is based only on the information provided in the affidavit. Ex parte relief restraining orders are temporary and are usually in effect for up to 14 days or until extended after a hearing. A hearing is required if the applicant chooses to ask for an extension of the ex parte order, and so the applicant and respondent can appear in court to testify. When the judge determines the type of restraining order to grant, the clerk's office provides paperwork to confirm the hearing date. This paperwork is called Order and Notice of Court Hearing. Once the applicant gives the paperwork to the marshal attempts to serve it to the respondent no less than 3 days before the hearing date. If the marshal cannot locate the respondent, an ex parte order can be extended to attempt to locate the respondent at the request of the applicant. In cases of domestic violence, a family relations officer will interview the applicant and respondent separately to determine a recommendation to make to the court.
So you're probably wondering where all of this happens. Hearings are held in and paperwork originates from the court in the jurisdiction where the incident occurred or where the applicant or respondent lives. Whenever an order is granted, the clerk's office notifies the police department. The applicant may also request the clerk's office to also notify school security, and it's the applicant's choice to alert anyone else, like family members or place of employment.
In some instances, there are people that are related to each other by blood or marriage that are seeking protection. Those individuals may come to court seeking relief from the other. If a person violates the conditions of an order, the person is subject to incarceration and will be charged with a felony that carries with it a period of incarceration of up to 5 years in prison.
If you're not sure what to do and you think you need protection, don't hesitate to ask. We invite you to visit our website, call us, email us, or visit us. And if we can't help you, we can usually refer you to an organization that can.